Continuation of the topic layoff. Special provisions related to layoff under Chapter 5B is being given in Industrial Dispute Act. That is, when layoff is being prohibited regarding the employer side is employer cannot lay off the workman under exemptions with the prior permission of the appropriate government except under the following circumstances: if there are shortage of power, natural calamity, if raw materials like fire or natural calamities in the form of flood, emission of inflammable gas or explosion has been happened, then employer cannot go with the layoff of workman. Then the same procedure is being followed when they are going with the layoff option also. As earlier I said, for retrenchment, the same procedure they have to go with the layoff. First of all, employer has to intimate with the government, and appropriate government will inquire about the layoff condition, and if it is genuine with the conditions of uh, workman. This is what the procedure usually happens when layoff is being carried out. Then these are all the special circumstances if the employer has already laid off workman due to the permissible reasons, still has to obtain permission in the prescribed manner in order to continue the layoff. If an applicable if an application for permission has been made up with the proper government approval, does not reply within 60 days, the permission is deemed to have been granted. These are all the special circumstances employer is being given under layoff conditions. Validity of government order when it comes with layoff, and government order granting or refusing the permission shall be binding on both the parties and shall be in force for a period of 1 year. That is, any order is being issued by the government means that it will be for 1 year according to the parties they are involving. Parties here in the sense both employer and employee. Then, as I said, this closure, uh, it is a permanent closing of a place of employment or part thereof. The condition has been given, and compensation during the closure of undertaking. As I said, before 60 days of notice period, they should inform the government. During that particular process, any compensation has to be given means then any workman who has been in continuous service not less than 1 year shall be paid compensation as if he had been retrenched, because almost retrenchment, if it has been in few days they are going to close the industry itself. For in that cases also they has to provide compensation. Further, if an undertaking is closed down due to exceptional circumstances beyond the control of employer, the total amount of compensation shall not exceed 3 months average pay of the employee. This is also has to be given during the process of closure. That is, during the closure of the industry, they have to abide with the compensation proceedings regarding the employee. Then exemption regarding the compensation to employees, financial losses, they cannot able to give any of the salary to the employees, accumulation of undisposed stock, expiry of the period of lease or license, exhaustion of minerals in an area means then they are unable to provide this compensation. These exceptions will be there. Then otherwise they has to go with the compensation option. As we come across with the same procedure of retrenchment or layoff, closure is also having the proper procedure to go with the closure of industry. Application for permission to the appropriate government and a copy has to be submitted 90 days before the date of intended closure, and government will inquiry, and after genuinity they will further pass the order or reject the refusal, and copy of the order is to be communicated both with the employer and the workman by the government. Then, as we are talking about Industrial Dispute Act, different settlement machineries in the form of conciliation officer, board of conciliation, uh, labor court, labor inquiry, court of inquiry, industrial tribunal, national tribunals, all these cases we are trying to mediate with the appropriate person which is being appointed, who is being appointed by the government, and proceedings will get settled with the award. Other cases, voluntary measures also been carried out to settle the industrial dispute when it happens without state interventions means, that is if uh, settlement without the state intervention is being involved in the industry, then how they can able to settle the dispute is one, as I said, before going with the settlement process or giving to the government and asking to settle the dispute, one they can go with collective bargaining with the employer, that is management can go with the process of bargaining. Other is voluntary arbitration. Voluntary arbitration is a mediator is being appointed who is genuine with both the parties, and then voluntary arbitration can be processed with the settlement of the dispute. This is a safer version of safer in the case voluntarily both the parties come to a settlement of disputes. Before going with the strike option, they can go with collective bargaining, or with the arbitrator, they can try to settle the dispute. The statutory measures for prevention, as we come across, these are all the things has been given here. Bi-party committees as work committees, what we come across, or compulsory collective bargaining, or with conciliation proceeding, or court of inquiries, or compulsory arbitration or adjudications are being carried out. Now we'll see one practical problem as a case which may be given in the questions. For example, an employer who intends to close down an undertaking service a notice of 30 days before the date on which the intended closure is to become effective on the appropriate government. Whether is this a notice valid? As we come across with the procedure of closure, as we said, proper notice has to be given with 60 days period, but this particular undertaking is being given 30 days. Then automatically what will be the answer for this problem is no, it cannot be considered as a valid notice as per section 25 FFE of Industrial Dispute Act 1947. As we mentioned, notice to be given before 60 days of closure. In this way only questions regarding the case studies also will be given according to the procedure regulations or the number of days or number of things which has to be followed in Industrial Dispute Act settlement procedures only. Practical problems or case studies can be given. Accordingly, you can able to answer the questions regarding the cases. By this, we come to the end of Industrial Dispute Act.